Welcome to the program. My name is Marty Shenkman, and I'm joined by Professor Mitchell Gans and Jonathan Blattmachr, and Robert Keebler is supposed to join us as well. And we're going to tackle yet another new development. It seems like there's been no shortage of new developments lately, and this is a big one. This is a potentially really big one, and I'm thrilled that Professor Gans is going to explain all of this in English so simple attorneys like us can understand it, because it ain't simple. We're going to talk about the recent Supreme Court case in Loper, and in that case, hang on one second. In that case, the Supreme Court overruled Chevron, and we're gonna get some insight on how all of that works. And what we're gonna do is start with a few introductory comments from Jonathan. Then we're gonna turn it over to Mitchell to explain what it all means. And then from there, we will open it up for the panel to try to explain what practitioners should be doing to address this. Just a few quick comments before we get started. The PowerPoint is available on the web console and will be posted to our website. We do not give formal credits, but you'll get a certificate of attendance, but those parameters may change depending on where you're viewing this. We'll try to give some articles as well to accompany the materials if we can, to give you more background on this important development with Loper. Before we get started, Teresa Bush from Interactive Legal was going to offer some comments. Teresa.
Thanks, Marty. Yeah, good afternoon, everyone. Interactive Legal is pleased to co-sponsor today's webinar on this very important decision. I was actually just discussing this morning with our CEO, Vanessa Kanega, who, like me, was a practicing estate planning attorney in a former life. And she mentioned that this is probably one of the most significant decisions in recent years, even though it is a bit in the weeds, but it gives us a chance to put on our nerdy attorney hats to think it all through. And I am very much looking forward to the guidance that we're going to hear today. As you probably know, Interactive Legal's flagship product is a document generation system for all types of estate planning documents, from the simple to the very complex. We are currently finalizing changes to some pending language now that we have the recently released secure regulations. And we will be presenting our transfer tax program via Interactive Legal Academy again in October. If you would like more information on Interactive Legal or the Academy, you can reach out to us at the website that was on the slide there, interactivelegal.com, and I will turn it back to you guys so that we can begin this presentation.
The other sponsors, Peak Trust Company, Andre Sears could not make the program, and I'll just suggest or announce that Peak Trust is really on the forefront of administrative trust companies. They have a facility in Alaska and Nevada, two of the top states for modern trusts. I believe they were expanding or will expand into Delaware, and I know they're even looking at other trust-friendly jurisdictions. Peak, as a practicing attorney, has been outstanding to work with, incredibly responsive, helpful, and really a pleasure to work with. And with the pressure that we're all going to face at the end of this year, as people are getting geared up to start funding trusts and planning pre-2026 before the end of 2024, it's great to have a partner that is by your side to help you. And the contact data for Peak is on the screen. So before we get started, Jonathan, you wanted to make a couple of general comments, and then we're going to turn it over to Mitchell.
You know, I just want to cover two things. When I was a very young lawyer, I had the privilege of being on the executive committee of the New York State Bar tax section, which was really a great body of great tax lawyers from New York. And there was a proposal made by a very important congressperson that any issuance of guidance by the federal government would not be binding. It would also mean that you couldn't rely on it. And the New York State Bar tax section took the position that that was bad because you want certainty in the law. In fact, when you think about it, the thing that distinguishes us from any other species is we have certainty with respect to certain things. I mean, the concept not just of stare decisis, but you can rely on what you've been told and things are not going to change willy-nilly is so critically important. And then came the Chevron decision, which Mitchell will go through, about 40 years ago, in which the Supreme Court basically said that unless the statute was absolutely crystal clear, and I'm going to make the point that I can't imagine any writing being crystal clear, that the agency which was in charge of that federal law could issue guidance in the form of regulations, and both the IRS and taxpayers could rely on it. And for many taxpayers, very important, that taxpayers could force the government to live up to its regulations. Mitchell, longer than anyone I've known, has been really on that, the Chevron doctrine. That was extremely important. And Mitchell has been tutoring me now for decades, literally, about how important Chevron is. And as Marty said, now it has been overturned by the Supreme Court. And I cannot emphasize how important this is. Some have said, well, it's not really that important. It is that important. And as Mitchell will explain, it will affect how you take positions on tax returns, how you argue cases before, say, an officer of the IRS or an appeals officer of the Internal Revenue Service, and also what you will say in court and how you will approach things. I cannot emphasize how important this decision, Loper right, is in changing that doctrine. And Mitchell knows more about this doctrine than anyone I know. And so, Mitchell, would you please tell us all about it?
Thanks, Jonathan, and thanks, Marty. Thanks for that wonderful introduction. I appreciate it. Very generous. Okay, so let's get started. It's a pleasure to be with you all today. So what I think I'd like to do is I'd like to start with a brief overview. And then as time permits, we'll get into the slides and dig into this more carefully. So as you've heard, Chevron has been and remains, that whole issue of Chevron has been and remains a very big deal, a very, very big deal in administrative law, not just in tax law. This is an administrative law phenomenon, and it has been huge and very controversial. In 1984, the court decided Chevron, and the effect of that decision was to do something that was somewhat surprising. The Supreme Court in Chevron surrendered to the agencies the authority to interpret ambiguous statutes. And I say surprising because, it's unusual for a court to say, okay, we've got this authority to interpret ambiguous statutes. We're going to give it up. We're just going to let the agencies decide. But that's what they did in 1984. And I won't go through now why they did that in the interest of time. Maybe if we have time later on, we can get back into it. But that's what they did in 1984. So they gave the agencies, they surrendered to the agencies interpretive authority with respect to ambiguous statutes. And now in the Loper decision, they of course have overruled Chevron. And in effect, what they've done is they've taken back this interpretive authority that they had given to the agencies in 1984. They've now taken it back to themselves. So the courts will now be back in the position, presumably, that they were in pre-Chevron to a large extent, and they will now be interpreting these ambiguous statutes for themselves, as opposed to allowing the agencies to do it. What is this really about? If we can pierce through the fog of all of this and try to make it very simple and get down to the nuts and bolts of it, what it's really about is a battle between people who like regulation and people who have trouble with regulation. I think that's really what it comes down to. Because if you think about it, if you're giving the agencies more authority, which is what the court did in 1984, you're going to have more regulation. You're giving life to regulations, more regulations. And if you don't like regulations, if you have some antipathy toward regulations, or you find them disagreeable in some way, then you're not going to like this, and you're going to want to have the courts take this back away from the agencies. You know, I think a good example to keep in mind as we work through this is the Environmental Protection Agency. You know, if you think about it for a moment, there are people who don't like the EPA and want to cut back on their ability to regulate. Well, if you are one of those people, if you want to cut back on the ability of the EPA to regulate, then you want to get rid of Chevron. You want to not have all of this authority in the EPA to engage in regulation. On the other hand, if you're one of those people who thinks that the EPA should regulate and that there should be more authority to regulate, or you want to beef up the authority of an agency like the EPA to regulate, then you are going to like Chevron. And I think that's really where the battle lines are here over this, this issue of Chevron or no Chevron, Chevron or Loper. Now, tax, I think, I've always thought anyway, let me just say, I've always thought that tax was just being swept along. I always thought that Chevron really was about, as I just said, regulation and how you feel politically about regulation, maybe politically, maybe economically, how you feel about regulation. I've always thought was the key issue. And I thought that tax was just being swept along. You know, in 2011, the Supreme Court decided a case called Mayo, and for the first time confirmed that Chevron applied in the tax world. Somebody's moving the slides on me here. Can we stay in the first slide for a moment, please?
Yeah, sure.
Thank you. So, so in 2011, the Supreme Court decided Mayo, and they said, you know what, Chevron is an across-the-board concept. We're not going to make an exception for tax. This is how we approach administrative agencies, and tax has to fall in line, and therefore the tax world is subject to Chevron, just like all other administrative agencies. Maybe you could think about this in terms of the dynamic of regulation versus people who don't like regulation so much. I mean, you could think about the IRS as a regulator. Think, for example, about the recent skirmishes and debates about the funding of the IRS. Isn't that a similar debate? Some people like funding the IRS, want, in effect, to beef up the power of the regulators, and others dislike it. And so, in a way, that's a kind of an iteration of the Chevron debate, if you will, regulation versus less regulation. Just yesterday, interestingly, some Democrats in the Senate, I believe, introduced legislation that would restore Chevron. Just to give you a sense, I started by saying how big a deal this is, and so you can see people in Congress really want to, at least some people in Congress, Democrats here, want to get Chevron back. Again, why? Because they like the idea, and Democrats generally do, like the idea of more regulation, and that's where they're coming from. By the way, interestingly, I'm not so sure what would happen if Congress did pass that kind of legislation. At least two justices on the court in the Loper case, Gorsuch and Thomas, indicated that they think that Chevron was inconsistent with the Constitution. And so I think they're sending a message that if you try to overrule us, if you try to restore Chevron, we may declare that legislation unconstitutional. The other justices in the majority did not go that far, and that's an interesting issue to think about. But you know, we'll see what happens. We don't know what's going to happen with that politically. I don't imagine the Democrats have the votes to restore Chevron.
And Mitchell, that's because basically what happens is that you would have under Thomas and Gorsuch would basically say you can't override the court's ability and responsibility to construe and enforce laws. It's not an agency which does that, it's the courts. And even though, as you pointed out, Mitchell, this overruling of Chevron under the Loper case turned upon the terms of the Administrative Procedure Act, they're saying it's a matter of the Constitution, that courts are the ones who get to interpret the law, not an agency.
Yes, I didn't mean to get into the constitutional argument here, and certainly not in the overview, but just briefly, as I understand the constitutional argument, it would be something like this. It would be that under Article 3 of the Constitution, the power to decide what statutes means is vested in the courts, not in the executive branch. Subject for the judicial branch, not the executive branch. And that would be, I think, the basic argument. And joining, I think, that argument would be Marbury versus Madison, which is cited in the majority opinion. You know, Marbury versus Madison says the courts are the ones who decide what the law is. And so I think that would be, those would be the key arguments, as I recall the arguments by Gorsuch and Thomas. Okay, so let's dig in here with all of that, with that introduction. Let's try to dig into this issue a little bit. So on this slide, I talk about the scope of the issue. What's the effect in the tax world? What's the real bottom line effect of this? And what I say here is that what we're dealing with only, exclusively, is the validity of regulations, okay? If you're talking about whether or not a revenue ruling, for example, or a notice is valid, that's not implicated here. That has nothing to do with Loper and Chevron. We're only talking here about the validity of regulations. So I say here, it does not affect sub-regulatory guidance, like, for example, what I mean by sub-regulatory guidance is something like a revenue ruling or, say, a notice, okay? So with respect to sub-regulatory guidance, not regulations, the law has not changed. They have always been subject to a weaker form of deference called Skidmore deference, named after a case that was decided back in the 30s, okay? And they remain subject to Skidmore deference, to that weaker form of deference. So you can already notice, by the way, that we've had two forms of deference. We've had Chevron deference and we've had Skidmore deference. There's a third strand of deference, which I don't think we're going to get into today. We'll see, but if time permits. But those are the two forms of deference. Skidmore is much weaker. We'll talk more about that a little bit later, but that's the bottom line. So the bottom line takeaway is we're only dealing in the world of regulations. If you're dealing with the validity of a regulation, then we're in my subject, right? Then we're in this question of, is it Chevron, is it Loper, how does it work? Okay, and that's where Loper has some real bite in terms of, and that's what we're going to get to. It has some real bite in terms of, and has some real impact, I believe. Some may disagree with me, but I believe Loper will have some real impact against the IRS, against the IRS. It's going to weaken the IRS. I'm in the middle of writing an article and I'm talking about how the IRS will have a weakened hand under Loper in terms of the validity of its regulations. Okay, let's change slides. Okay, so what I say here is I've told you now that regulations are what we're dealing with, the validity of regulations. And what I clarify on this slide is that we're dealing with the validity of pro-government regulations. You know, you're faced with a regulation that's against your client, and you want to argue that that regulation is an invalid interpretation of the code. That's what we're talking about. How the arguments that will be made by you or your client against the validity of such a regulation, how that's going to be impacted by Loper. That's what we're discussing. So I asked this question, what about pro-taxpayer regulations? Will the IRS come in and say, oh, you know, there's a regulation on the books here that works for you, pro-taxpayer, but we're going to argue that it's invalid, that it's wrong. It's a wrong interpretation. We want to take it back. And I think that's not really the subject of the discussion today. I want to talk principally, if not entirely, about pro-government regulations. But I do briefly want to mention here that if the government were to try to take back a taxpayer-friendly regulation, I think there are serious issues with that. It's an interesting, complicated subject. I threw some citations here at the bottom of the slide. There's this recent case in the tax court, the Amgen case. It was decided just a few weeks ago. You can see on July 3rd. And in this order, it was an order on a motion for summary judgment. The court talks about how maybe if the IRS were to try to take away a taxpayer-friendly position that the taxpayer had relied on, that might violate due process, which I think is kind of interesting. And Brownhorst is another interesting case which says that when the IRS comes to the tax court, it should not be arguing against its own outstanding revenue rulings. Well, if it can't argue against its own outstanding taxpayer-friendly revenue rulings, all the more it shouldn't be able to argue against its own taxpayer-friendly regulation. So bottom line is, I think I've now given you a sense of what I want to talk with you about today, and that is the validity of pro-government regulations. If you're worried about pro-taxpayer regulations, you can take a look at these authorities that I've cited, but it's not really the subject of today's discussion. Let's change slides. Let's go back and take a look at what the world looked like before Loper was decided last month, or earlier this month, okay? Before Loper was decided, we lived since 1984 in a world of Chevron, okay? And we had, as I said a moment ago, we had two forms of deference. We had Chevron deference, we lived with Chevron deference. We also had this second form of deference, Skidmore deference, okay? Which we're gonna dig into in a moment. As I said before, Chevron was applied by the Supreme Court, the Supreme Court said Chevron is applicable in tax cases in the Mayo case. Notice that, and if we have time, I'm going to pick up on this later. Notice that in Mayo, I think this is an interesting point. Notice that in Mayo, the regulation that the court upheld, the Supreme Court in Mayo upheld the regulation under Chevron. That regulation in Mayo was issued under Section 7805. Okay, that's the general authorization in the code for the IRS and the Secretary of Treasury to issue regulations that interpret the code. Okay, and it applies across the board. And we'll talk more about that later, I hope. Skidmore, as I've already said, applies to all other forms of guidance, a revenue ruling, a notice, a weaker form of deference. Okay, let's change. So how did Chevron work? Okay, so what Chevron did was this. It asked essentially two questions, okay? And people called it step one and step two, all right? So step one asked, was the code section or the statute, if we weren't dealing with tax, was it ambiguous? Okay, that was step one. If the court determined it was not ambiguous, that it was unambiguous, that was the end of the matter. The IRS could not interpret its way around it, could not issue a regulation changing the meaning, the unambiguous meaning of the statute. And that makes, I think, constitutional sense. The agency, the executive branch, the agency sits in the executive branch. The agency does not have the authority to rewrite unambiguous statutes passed by Congress. That's Congress's job under Article 1. The agency sits under Article 2. It doesn't have the power to do that. So if the statute was unambiguous, end of subject. That was step one of Chevron. If the court determined that the statute was ambiguous, the step one, then it turned to step two, which was whether or not the agency reasonably resolved the ambiguity. And by the way, once the courts determined that the statute was ambiguous, it was overwhelmingly likely the court would turn to step two and say, no problem, the agency reasonably resolved the ambiguity. And that was a very powerful piece of authority the agencies enjoyed under Chevron as a practical matter. So the agency, if it adopted a reasonable resolution of the ambiguity, people might differ. I might say as a taxpayer, hey, I don't think you should resolve the ambiguity in the statute that way. The agency says, the IRS says, yes, we think that we should. The agency did not have to be right. It only had to choose an alternative that was reasonable. And that was key. Very key. So you might look at the code section and say, hey, it could mean this, it could mean that. The IRS gets to choose. That's what Chevron said. And you see, therefore, in this moment, the power of Chevron in the hands of the agency. The agency, the IRS, got to choose as long as it made a reasonable resolution of the ambiguity. Here I say in the middle, around the middle of the slide, well, let me come back up to the top for a second. Notice that language, force of law. That was language we saw under Chevron, that the regulation was given force of law effect. It's as if it had been passed by the Congress. Their regulation, if it reasonably resolved the ambiguity in the code, it was as if that regulation had been passed by Congress. It was force of law. Very powerful concept, I think, in the hands of the agency. Now look at the middle of this slide. The agency's interpretation under Chevron did not even need to be what the court considered the best interpretation. The court could be sitting there saying, you know, in our view, the best interpretation of the statute goes for the taxpayer. But you know, we cannot deny that the IRS's interpretation in the regulation is a reasonable one, okay? It's not the best one. We would have chosen differently had we had the authority to do so. But after all, we must remember that under Chevron, we gave this interpretive authority to the agency. We got out of the business of doing this. We surrendered our authority. And so even though we don't think it's the best interpretation, if it's a reasonable one, we're required, the court said, to defer to the less than best interpretation provided by the IRS in its regulation. Really an amazingly powerful concept if you think about it. Okay, next slide. So what I say here is the two big C's that we'll be talking about today. I think that as we get through Loper, we're going to see these two big C's are important. So I call them the two big C's. And what they are is one, consistency, and two, contemporaneousness. How do these factors plug in to the analysis? How do we consider these factors in determining the validity of a regulation? What if the IRS, I say in the top of the slide, had not been consistent? You know, they flip-flopped. They said, we think the statute means this, then they said, we think the statute means that. And how does that impact the analysis? For example, in Mayo, they had an interpretation that was one way under a regulation for a period of years. Then they flipped and they issued a new regulation and took the opposite approach. And the court in Mayo said it's a valid regulation because inconsistency under Chevron was irrelevant. So the fact that the agency read it one way day one and a different way day two did not cut against the regulation. Inconsistency was just not a problem, and that's pretty amazing. You know, you got an agency like the IRS saying we read it your way first. Well, now we read it our way, and we don't impeach them. We don't say, oh, that's inconsistent, that's problematic. Quite the opposite. Under Chevron, inconsistency was irrelevant.
Tell us about the Smiley case, because I remember when you told me about the Smiley case, I couldn't believe that this happened.
Yeah. So now contemporaneousness. Let's slip down to the second big C, right? And I'll put this all together before we end today in terms of Loper. So what about contemporaneousness? Now, what do we mean by contemporaneous? Okay. Well, here's the idea. Congress enacts a statute, and shortly thereafter, the agency issues implementing regulations. Think, for example, I don't know, the Secure Act, right? The Secure Act gets passed, and the agency goes to work on issuing regulations, trying to interpret and flesh out that amendment. Those regulations would be viewed as contemporaneous. What about if they're not contemporaneous? As in Mayo, for example, where they had taken one position when the statute was enacted, and then years later they wanted to flip-flop, and the court said, that's okay under Chevron. Consistency is not a problem, nor do we require that the regulation be issued contemporaneously with the statute. We don't require contemporaneousness. And as Jonathan was just saying in Mayo, which I have on the bottom of the slide, shocking, right? This is a non-tax case, but cited in Mayo.
Smiley, not okay. Mayo, Mitchell. Smiley, not
Mayo. Forgive me, Smiley. Yes, I misspoke. Thank you, Jonathan. Smiley. In Smiley, which I have at the bottom of the slide, cited in Mayo, non-tax case, we have a regulation that was issued 100 years after the enactment of the statute. 100 years later, somebody woke up and said, let's interpret it this way with a regulation. And the court said, valid under Chevron.
And then Mitchell, that was, even though there was an original interpretation, and then essentially 100 years later, they said, we've changed our mind.
Right. Consistency was not a problem under Chevron, nor was it required that the regulation be contemporaneous.
Right. I mean,
now, if you think about that, that gives the agency breathtaking authority. And we're going to see an example. I'm going to talk about some 2009 regulations in the estate tax area that will bring this home. But if you think about it, the IRS wakes up one day and says, you know, statute was enacted many years ago. Let's issue a new regulation that cuts our way. Well, under Chevron, that was permitted as long as the statute was ambiguous, step one, and in step two, the agency's resolution of the ambiguity was a reasonable one. And as I say, it was very difficult for taxpayers to win under step two. Once they got over step one, the court determined the statute was ambiguous, the regulated party or the taxpayer in the tax world was going to lose in probably almost every case. Okay, let's change slides. So here, Jonathan and I wrote an article. I think we first did this, if I recall correctly, Jonathan, with Carl and McCaffrey. And then I picked up on it in later articles as well. This term, declaring victory by regulation. Okay, so what do we mean by that? And so the question here is, what if the IRS were to lose in court? This is all under Chevron. What if the IRS were to lose in court? Now, by the way, let me just justify what I'm doing here. You may be saying, why are we studying Chevron if it's no longer the law? Because all of these things are now going to disappear under Loper. And in order to appreciate the practical consequence of Loper, you need to see what was in place before and what's no longer. And that's what I'm trying to set up for you. Okay, so what if the IRS lost in court? Could it issue a regulation overruling the court's decision, perhaps even the Supreme Court? Now, I got to tell you, whenever I've talked about this issue over the years, in class or with practicing lawyers, I always get these looks like, you got to be kidding me. There's no way that an agency can write a regulation that overrules a court decision. That can't be right. It's so counterintuitive. Well, under this case I've cited here, non-tax case, applying Chevron, the court said, yes, the agency can rewrite, can override, can overrule the court decision unless the court had held, and hold is a key word, not in dicta, not in passing, had held that the statute was unambiguous. As long as the court did not hold that the statute was unambiguous, the agency was free to override the court decision by a regulation. And that's why we called it declaring victory by regulation. You lose in court, the agency loses in court, you come back, the agency now declares victory by regulation. I can tell you, by the way, that this was the most disturbing thing to me early on. And in fact, in my scholarship, in my writing, I argued against Chevron. One of my first big law review articles in this area, I think it was titled something like Deference, which was Chevron, and the End of Tax Practice. I thought that they were really turning tax practice upside down, that they were making the IRS into a super adversary. You know, what adversary can you imagine having who gets to rewrite the rules and declare their loss invalid, overturn it if they don't like it? I mean, well, very powerful.
In the article that you and Carlin and I wrote, which was originally in Tax Notes, it was based upon a Supreme Court decision. And in effect, the Supreme Court actually invited the Treasury Department to change the regulation to the way it wanted, and that's exactly what happened. So this was exceptionally powerful in the hands of any agency, including the Internal Revenue Service. So you get a case come down by the Supreme Court, which says pro-taxpayer interpretation of the regulation, and then the agency changes it, and now you can no longer rely on that taxpayer-friendly interpretation of the law.
Yes, and we've been living with that, those regulations, those anti-Hubert regulations. This is the Hubert case, right? For years, they're in the marital deduction provision, and they deal with management fees and transmission fees. For anybody out there who's familiar with those terms, all of that comes from the IRS overturning the decision in the estate of Hubert that was rendered by the Supreme Court. Okay, next slide. Now, I'm just digging in a little bit more on declaring victory by regulation under Chevron and Brand X. That was the case I cited on the last slide, which was simply applying Chevron. What about the fact that the agency had been inconsistent? It's got this new regulation, it's overturning the court decision. Inconsistent, it had taken a different position, and irrelevant. Inconsistency, no big deal. Under Chevron, you can be inconsistent as you want. Lack of contemporaneousness, Smiley. They come out with a regulation 100 years after the statute's enacted, no problem, Chevron deference. Heat of litigation, and what I mean by that, of course, is that's a term we've seen in the courts. What I mean by that is, you know, they've been litigating the issue, they may have lost it in some courts, and now they want to overturn their defeats, no problem. That's Brand X, the case we just cited on the last slide. Okay, next slide. Now, Skidmore deference. Let's talk for a moment about Skidmore deference before we connect up to Loper. So under Skidmore deference, which as I told you, remains in place. Now, I think listen carefully here, because here we're going into what the new world is going to look like. Okay, so we've always had Skidmore since, you know, the case Skidmore was decided somewhere in the 30s. And we learned over the years, case in 2001 in the Supreme Court called Meade, which I haven't cited here. But in the Meade case, the Supreme Court said essentially, you've got Chevron and you've got Skidmore. regulations qualify. I'm doing this very quickly, but essentially tax regs qualify for Chevron. Everything else, like rulings and notices and such, qualify for this weaker form of Skidmore deference. Now, here's the key thing. Under Loper, Skidmore now applies to regulations. This weaker form. Now, when I say weaker, think about the IRS having a weaker hand, the taxpayer having a stronger hand in litigation concerning the validity of regulations. Loper is saying we're going to get rid of Chevron, and now everything is subject to Skidmore. So in the tax world, everything is now subject to Skidmore, sub-regulatory guidance like a revenue ruling, as well as regulations. I cited a case that Jonathan and I think, Jonathan, you've written about this case, if I recall correctly, the Weber case, right?
Yeah.
And in Weber, the court, it was a split dollar insurance case, if I recall, but in Weber, the court, no, I don't think it was split dollar. Actually, it was not. It was private placement insurance, I think.
That is correct.
Right, forgive me. And so Weber was a case where if you're interested in seeing Skidmore being applied, they upheld revenue rulings, they deferred to revenue rulings under this weaker form of Skidmore deference. So there's a place to look if you'd like. I just thought I'd throw that in, but we're going to try to give you a little bit better sense of how Skidmore works as we move forward. Can you change slides for me? So as I say, and I've said already, I'm sorry, can you go back one? Yeah, okay, I'm good. Next slide. Okay, so here's how Skidmore works, all right? The ultimate question for the court to decide is what is the best reading of the code? The court reads the code section and it construes it to determine what it thinks is the best reading. Now notice, under Chevron, the court could have said, hey, we think the best reading is for the taxpayer, but that was irrelevant because as long as the IRS had a reasonable reading, even though the court thought the best reading was for the taxpayer, the court would defer to the IRS's reading, okay? That's now gone. Now, if the court thinks that the best reading is for the taxpayer, the IRS's regulation to the contrary must fall. It must yield. So that's a very big issue, it seems to me, in litigating with the IRS over the validity of regulations. They now have to sustain the burden, if you will, of establishing that their reading in the regulation is the best reading of the code, okay? Now, the court does look at what the IRS has said, does look at the regulation, and the question on the Skidmore, as I say here in the second point under the first, in about the middle of the slide here, is the IRS's interpretation of the code set forth in the regulation persuasive? Are we persuaded by their interpretation? So we don't have to defer. We're not locked in as we were under Chevron. The court's not. The court says we have to think about what we think is the best reading of the statute. In trying to get to that conclusion, we will look at what the IRS says in the regulation and see if we're persuaded by it, okay? Now, in determining, now look at the bottom of the slide, in determining whether we think it's persuasive, we take into account some factors. And here we see the stuff I've been developing with you as we talked about Chevron. Agency consistency. If the agency has been inconsistent, they flip-flop. They had a position for some period of time. Now they've changed positions. That's going to cut against the agency. That's going to cut against Skidmore deference. It did not. Under Chevron, agency inconsistency was irrelevant. Under Skidmore, it is very much relevant. And if the agency has been inconsistent, I think they're not going to get any Skidmore deference at all. The court's just going to say, we think the statute means whatever. They're going to make their own decision. Contemporaneousness. Just like contemporaneousness was irrelevant under Chevron, remember the Smiley case, the regulations issued 100 years after the enactment of the statute, it was binding on the court. No more. Under Skidmore, contemporaneousness is a key factor. If the regulation comes in sometime after the enactment of the statute or the amendment, that's going to cut against any deference for the IRS's interpretation. Heat of litigation. I think heat of litigation is another factor that will cut against the agency. If they've been litigating the issue and now they want to take a position so that they can somehow use it, leverage it in litigation, or they want to overrule prior decisions. Not so fast. They're not going to get any Skidmore deference, in my view, in terms of Skidmore. Okay, so I think those are the key relevant factors. Let's take a look at the next slide. Here's an excerpt from Loper. Okay, let's look at this and then we'll take it apart in the next slide. It's pretty much saying what we just said, but let's take a look at the language. This is the language of the court. Agency interpretations constitute a body of experience and informed judgment. Now, of course, when they're talking about agency interpretations in our world, what we're talking about, as I've said repeatedly now, are tax regulations, right? So regulations, if I can substitute that in for this language, regulations constitute a body of experience and informed judgment to which courts and litigants may properly resort for guidance consistent with the APA, that's the Administrative Procedure Act. Okay. Now here's the key sentence. And interpretations issued contemporaneously, I've underscored the word, that's my emphasis, I've underscored the word contemporaneously, the big two C's, okay? And interpretations issued contemporaneously, one big C, with the statute at issue, and which have remained consistent, second big C, over time, may be especially useful in determining the statute's meaning. So what is the court telling us here? Well, it's telling us that they are prepared to say on the Skidmore that if we see a regulation that is contemporaneously issued with the enactment of the statute, and that interpretation or regulation has been consistently adhered to by the IRS, there's no flip-flopping, then we are going to be we're going to find that especially useful. They're not saying they're locked in, but you can read in between the lines and think, well, they're going to be very likely to give it Skidmore deference. But although they don't say this, I think the implication is that if the government has not been contemporaneous, or if it's not been consistent, in other words, if it fails one of the two big C's, we're not going to give it much, if any, deference at all. We're going to look at the statute and try to figure out ourselves what it means and disregard the regulation. So here's your attack, right? If you're representing a taxpayer and you want to argue that a regulation is invalid, I think you're going to be looking at the two big C's under Skidmore. Those two big C's would not have helped you under Chevron, but they're going to become your friend under Skidmore. Was the agency, the IRS here, lacking in terms of contemporaneousness or lacking in terms of consistency? That's where your attack is going to be. And there's Mitchell, the passage from Loper, which suggests that.
Mitchell, when you say issued contemporaneously, when you use the word issued, is that a proposed reg, a final reg?
Oh, I think if for example, let me try to give you a concrete answer to that. Let's stay with the Secure Act, right? Secure Act comes out, and shortly thereafter, the IRS issues proposed regs. And then, they go through notice and comment, they issue proposed regs complying with the APA, and then thereafter they get comments, and then thereafter they finalize the regulations. That's going to be viewed as contemporaneous.
But you have, for example, the, I think it's private annuity regs were proposed a dozen years ago, never finalized. How would you view that?
I don't think that would be contemporaneous at all. There was no statute that was enacted or amendment that was enacted that precipitated those regulations, right? That's just, I mean, I'm speaking, I didn't expect you to raise that one. I'm speaking off the top of my head here, but as I recall, when they came out with that guidance, it had nothing to do with a new amendment that it just came out. They decided this is the way we want to attack private annuities.
Right.
And there was no antecedent amendment to the code or no enactment of some section of the code on which that guidance was predicated. And so they don't even purport. I mean, if you go back and look at the guidance, and again, you got me, you're raising something off the top of my head, I'm reacting. But I guarantee you, there's nothing in that guidance which says this is predicated on a recent amendment. Or this, you go look at the Secure Act regulations, you'll see they talk about this statute was passed and we need regulations and so forth.
Right. Well, another one that I think is maybe of interest to everybody is the split dollar rules. The IRS came out with split dollar rules beginning in 1955. It completely changed its position in 1964. And then it completely changed it again in the beginning of the 1980s. And then it finally came out with regulations. And they're quite detailed. And whether or not that would be any part of those regs would be upheld when there was no statute ever enacted. It's based just upon the concept, basically, of what is gross income. I think those are probably subject to a real attack on the basis of no, certainly not even Skidmore deference. So it's been inconsistent. It wasn't contemporaneous. It's changed its mind at least 3, maybe you can count 5 times as to how you treat a split dollar arrangement. And that's a very big part of the insurance industry. And I'm sure that some people will say, I can go back and I can have a split dollar agreement of the old type under the 1955 revenue ruling. These were revenue rulings. And then in 1964, and then finally regulations that came out in the early 2000s.
So I think the takeaway here is, if you know, the cash out for everybody listening is the 2 big C's. You know, that's the way to think about attacking regulations. You know, are there problems with the 2 big C's? Okay, let's change slides. So I gave this example. Now, Jonathan just gave the split dollar example, so maybe I can just bypass this one. Although I like this example, let me try and do it briefly. In 2009, for those of you who practice in the estate tax area, in 2009, there were new regulations issued under Section 2053. Okay, I've got the citation up there on the slide. And essentially what they said is, let's say I die and there's a claim against my estate. Can my executor take a deduction for that claim? Well, let's assume the claim at the time of my death was for $100 million, just to make up a crazy number, right? And then it's settled for $10 some years later. Can you take the deduction for $100 million, or are you limited by the amount you actually settled it for $10? And believe it or not, there were some contrary decisions on this issue in the courts, because as I say here, I cite to this Ithaca Trust case in the Supreme Court. Under Ithaca Trust, it was not a 2053 case, it was a charitable deduction case. But under Ithaca Trust, you're supposed to take a snapshot of what the person owned and what happened in terms of charity, you know, at the moment of death. It's a snapshot concept. We don't look at post-death events in general. And so a number of courts, or some courts, said, hey, the fact that a favorable settlement was reached after death should be ignored. The question is, what did the claim look like at the moment of death? We need to determine how much of a deduction should be permitted based on the facts in place at the moment of death. And so the IRS came in here and said, you know, we're going to clean this whole area up. We think there are conflicting decisions. And if you go back and you read the preamble, you'll see they talk about how there are conflicting court decisions, some of which said, oh, under Ithaca Trust, you really should take that snapshot at the moment of death and ignore post-death events. Others of which said, hey, look, if you get a favorable settlement, we need to take that into account. And in my crazy hypo, you should only get a $10 deduction. Well, the IRS came in, they said, we're cleaning this up. We're going with the cases we won. And we're going to invalidate or say the cases we lost no longer count, okay? And that was under Chevron. I think if you had asked me a year ago, how are those regs look? I think, Jonathan, you and I wrote an article about these regulations at some point. I don't think we ever suggested that these regulations were vulnerable rather, to a validity challenge given Chevron, you know, and I think a challenge would have been probably impossible. The fact that there was no statute, there's nothing contemporaneous. There was nothing enacted. There was no predicate. There was no statutory predicate for this change. They had just looked at the cases and said, let's clean this up and say we won and call it a day. and so there was no contemporaneousness. There was no, I think it's heat of litigation. They're overturning court decisions, and that's going to be very suspect under Skidmore. That was okay under Chevron, very suspect, probably not permissible under Skidmore. And so I would think today, a taxpayer faced with a problem under these regulations would have a very interesting challenge that they could make to the regulations under Loper. I say at the bottom of the slide, Loper/Skidmore, just to remind you that what Loper has done is it's brought Skidmore into the world of regulations. Because Chevron is gone, the world has gotten easier. We now have only one, essentially only one form of deference, and that's Skidmore, and the 2 big C's are critical. Okay, next slide. What about regulations issued, I talk about on this slide, what about regulations issued under a specific grant of authority? So you remember at the outset, I talked about before how regulations get issued generally under 7805. That confers general authority, that section, on the IRS and the Secretary to issue regulations that interpret the code. If you go look at 7805, as I recall, the word interpret is there. So that gives the IRS and the agency, the IRS and the Secretary, authority to issue regulations that interpret. Look at what about in contrast a specific grant of authority? So I just grabbed this one out. I'm not sure why I chose it arbitrarily. In 469, the passive loss section, they have this provision: the Secretary shall prescribe such regulations as may be necessary or appropriate to carry out the provisions of this section, including regulations. And then they go on talking about various issues that regulations could address. Okay, so this is over and above 7805. This is what I would call a specific grant of authority. How are we going to deal with specific grants of authority like this one, aside from or over and above, if you will, the 7805 authority? So I'm suggesting that you need to distinguish between a 7805 general authority reg, a 7805 reg, versus a specific grant of authority reg like the one I have as an example on the bottom of this slide. Okay, now here's why. Can we change slides? Okay, here's a key passage that's going to be a very important moment, if you will, in the Loper decision. And I think it's really an important passage, and important enough for me to put it on one of the slides. So the court says here, when the best reading of a statute is that it delegates this, by the way, you notice best reading, that's their phrasing. I keep going back to the term best reading. They're talking about it here. When the best reading, we look at the statute and we figure what it means is that it delegates discretionary authority to an agency. Okay, when the statute does that, delegates that's the key, discretionary authority to the agency. The role of the court, of the reviewing court under the APA, the Administrative Procedure Act, is, as always, to independently interpret the statute and effectuate the will of Congress subject to constitutional limits. Okay, doesn't say very much. The court fulfills that role by recognizing constitutional delegations. We can talk about what is a constitutional delegation in a minute. Okay, fixing the boundaries of the delegated authority and ensuring that the agency has engaged in reasoned decision-making within those boundaries. Okay, big mouthful. I'm going to try to take that apart for you on the next slide. But the bottom line is the court is saying something very important here. As I interpret this paragraph, and as I apply it in the tax world, when you're dealing with a specific grant, like the one we just saw in section 469, we're in a different world. Here, we're not going to simply apply Skidmore. Here, the agent, bottom line, from 30,000 feet, the agency is going to get more maneuvering room. The agency is going to have more authority. And if you think about it for a moment, I think that makes sense, right? The Congress has decided to delegate to the agency some discretionary authority. And in a case like that, the court is saying we're going to give much more room than Skidmore permits to the agency. So I think a threshold question for practitioners, if you're thinking about challenging the validity of a regulation, is to determine at the outset, what kind of reg do I have here? Do I have a regulation that's just a normal 7805 regulation, or do I have a regulation that's issued under a specific grant like the one I showed you in 469? And believe it or not, there are a number of these specific grants in the code. And so I think it's very important. In fact, when Jonathan first raised with me the split dollar regulations, what is it, 61-22, I think it is, right, Jonathan?
Right.
When Jonathan first asked me about that in light of Loper, the first question I think I asked was, and that we looked at together, if you recall, Jonathan, was, is there anything in section 61 that makes a specific grant of authority? Because you see where my thinking was. I want to know right up front at the outset, what am I dealing with? Am I dealing with a Skidmore challenge, or am I dealing with this paragraph in Loper? Because this paragraph says, hey, Skidmore no longer doesn't apply in this context. Is there a delegation of discretionary authority to the agency?
And indeed, Mitchell, you and I went through, and there are dozens of different ways, literally dozens of different ways that the agency, in this case, the Secretary of the Treasury, the IRS, is actually given authority. And they're phrased very differently, and how they would be interpreted based upon the specific words to grant the agency some sort of power to issue regulations. It varies tremendously. And
Yes.
I don't know whether it'll come down and the courts will say, yes, in this case, you have a lot of authority, so we'll defer. And in this case, yes, this authority, but we don't think it's as broad as it could have been.
Yes, I think it's going to be a critical threshold question. In fact, I might just say, over the weekend, I was looking at the new Secure Act regulations, trying to understand them, and I was thinking about an area that struck me as counterintuitive, the position they were taking, and I went back and looked at 401A9 just to see if there was anything in there that would trigger this paragraph in Loper. And I saw some language in 401A9 talking about in accordance with regulations. So there's an interesting moment. In accordance with regulations, is that the stuff of a delegation of discretionary authority? It's so light you hardly notice it. In accordance with regulations, it doesn't say as 469, as the excerpt I just showed you from 469, which is a much more robust form of delegation to the agency. This is so minor you hardly know it's there. And so will that constitute a form of delegated discretion sufficient to trigger this paragraph in Loper? I have no idea, but you could see where litigation might be going over the years under Loper. Okay, next slide. All right, so here I just try to take this apart a little bit. I think we're running a little thin on time, are we not?
We are, but keep going, keep going.
Okay, so let me try and work through this slide relatively quickly. I'm just taking apart that paragraph, what I consider that key paragraph that I just showed you from Loper. Because you remember there were a couple of elements in that paragraph, and I'm just trying to stake them out here so you can get a sense. Is the delegation constitutional? So they threw that in, okay? And I don't know if it's worth talking much about that here. I'll give you just a few seconds on it. This question of how much Congress can delegate to agencies has become a controversial issue. There are people who argue that delegations by Congress to an agency to write up laws and regulations, that's unconstitutional perhaps, because that's the function of the Congress. It's an Article 1 function, and it should not be delegated to the executive branch under Article 2. Okay, so the courts, the Supreme Court, and the best case on this is the Gundy case I've cited. The Supreme Court has talked about whether or not the delegation provides an intelligible principle. That's their phrase. In other words, does it give some guidance on what Congress anticipates? If Congress just said, hey, do what you want, that would probably be unconstitutional. In any event, this is a controversial area, and I think Roberts, who drafted Loper, threw in, oh, by the way, it's got to be a constitutional delegation. He didn't want to inadvertently get himself involved in that issue, that provocative issue. So he just threw that word in, and that's what that's about. Second, is the agency's position within the scope of the discretion conferred by the statute? Is it whatever discretion Congress contemplated, did they stay within it? So for example, if it was, I don't know, to make up a crazy example, if they said, make up rules about deductions, IRS couldn't use that authority to make up a rule about gross income, right? That would be beyond the scope of delegated discretion, just to give you a very clear cut, but somewhat unusual or crazy hypo to illustrate it. Finally, did the agency comply with the APA? That's the Administrative Procedure Act. And that's nothing new and nothing of any moment here, because every regulation, every regulation has to comply with the APA. So to say it has to comply with the APA doesn't add very much. The APA requires, as the Supreme Court has fleshed out, the APA requires reasoned decision making. So the agency has to consider, for example, and you've probably seen this. I think we're going to have something on a slide in a bit. Has to consider comments that were made. You've got to have notice and comment, and it's got to be real comment, and the agency has to respond to the comments. And if it doesn't respond to the comments, then it hasn't engaged in reasoned decision making. Has it responded in a way that's reasoned, or has it just blown it off in an arbitrary manner? Then it would be arbitrary and capricious, and it would not comply with the APA. But that's true of all regulations. So he threw that in just to make sure he was covering his base. The key takeaway from this passage in Loper, I think, and where the battles would be, is whether the particular regulation was within the scope of the delegated discretion. You know, if lawyers out there, the concept of ultra virus comes to mind. You know, is it beyond the scope of the authority conferred? It's kind of got that flavor to it. Okay, next slide. Okay, now, is this Loper passage that we've been discussing Chevron Redux? So what I mean here is that passage going to really put Chevron back on the books? Have we just changed the name of this whole thing and gone through these gymnastics to all come back to the same conclusion, which is it within the scope of the delegated discretion? And if so, that's going to look a heck of a lot like Chevron. And I've seen that argument made. I've seen that argument made by some very reputable, respectable people. So I don't agree with it. In my view, here's how I believe it's going to play out in the tax world. I've got an article coming out in Tax Notes where I'm arguing this. I believe that we're going to make this dichotomy. We're going to say, is this a 7805 regulation? Was it issued pursuant to the authority of 7805? Is that where the agency, is that how the IRS predicated it? Or did they predicate it on some specific grant? Excuse me. If it's a 7805 regulation, I believe that we're going to be looking at Skidmore and Skidmore only. And the two big C's are going to be the key issues, okay? On the other hand, if we're dealing with a specific grant, then I think that we're going to be looking at that passage and asking whether it's essentially ultra-virus. Is it within the scope of the delegated discretion? And I think that's a key issue. As I said, Jonathan and I, when we had this discussion about the split dollar regs, I said, we got to look and see, is there anything in section 61, because it was all issued under 61, giving the agency, making a delegation of discretionary authority to the agency, a specific grant. And I think that's going to be a key issue. Next slide, because I'm going to pick up on this point. Yeah, so let me just tell you about LISAC, which kind of supports my thinking. I think. So, and I think this is an interesting moment for us. So LISAC, which you could easily miss, okay, because it was just a decision by the Supreme Court on July 2nd, right after they decided Loper, where they vacated and remanded a tax case, important to us, right, to us tax people. They vacated and remanded a decision by the DC Circuit in a tax case. It was a whistleblower case, but it involved a section of the Internal Revenue Code, okay? And they remanded to the DC Circuit for reconsideration in light of Loper. So that sends a pretty strong message. Now in the DC Circuit, the court had upheld the regulation under Chevron. And now the court is saying, hey, we want you to reconsider this in light of Loper. So that, I think that sends a very strong message, and I think the courts will take that as a strong message that things have changed. And whether or not regulations are going to be valid, there was a challenge to the validity of the regulation there. It was upheld in the DC Circuit under Chevron. And now we see the Supreme Court saying, go back and take another look at this because Chevron obviously doesn't apply. So I think this is a really important moment. Now, what does this mean? I don't know. The court doesn't tell us. It just simply says we're vacating and remanding for consideration in light of Loper. I thought it was interesting that the section of the code that they were that was at issue in the case is section 7623, and you notice there's a grant of authority in there. The secretary, this is an excerpt from 7623, the secretary under regulations prescribed by the secretary is authorized to pay such sums to whistleblowers as he deems necessary for, and I left the rest of it out. So we may see the DC Circuit grappling with this issue. Is that a specific grant of authority? It looks like it. And therefore, does it come within that passage in Loper? Or is this just a Skidmore case? But it goes to prove, I think, that the Supreme Court anticipates that the tax law is going to be having to deal with and live with Loper, right? That's clear. And so I think in that sense, I thought LISAC was interesting. I wish I could give you more about the specific grant of authority issue, but of course the Supreme Court gives us none of that. They simply vacate and remand. Okay, next slide. Okay, so here's the key. I think I've made this point all along. I'm kind of coming to my conclusions here, but is the taxpayer, I ask, is the IRS position on regulations weaker under Loper? I believe absolutely yes. Okay, there may be others out there who will say no. Maybe that passage in Loper is going to apply? I don't think so. By the way, let's just spend a moment on the other argument. Maybe the IRS will argue that 7805 delegates to them the authority to do this, that's like a specific grant in some way, that's a delegated grant of discretion. I don't believe that flies, because I think all 7805 does is it gives the agency, the IRS here, and the secretary, the authority to interpret. That's all it does, to interpret. And under Loper, the interpretive function, the court says, belongs to the court, no longer to the agency. So you can see, I fleshed this out in my tax notes article, which will be coming out shortly. If anybody wants to talk about it afterwards, we can. Let me just go forward here so we don't eat up the time that's remaining. As I say here on this slide, taxpayers have begun to make the argument that the IRS is in a weaker position, okay? That these regulations now need to be looked at through Skidmore, not through Chevron. The IRS has a weaker hand. So I point out here that in the partnership, here's a partnership anti-abuse reg. Now this is interesting, I think. So in the Tribune Media case, the court and the tax court applied the partnership anti-abuse regulation. And the taxpayer has just made a supplemental filing in the circuit court saying that this regulation, now think about this, think about how powerful this is. It just really gives you a snapshot of how powerful this Loper decision could plausibly be, right? The taxpayer is now arguing that the anti-abuse partnership reg, which is, I think, an important reg, right? Certainly from the IRS's perspective, is invalid because under Loper, we have to apply Skidmore. And there was no contemporaneousness, and I don't remember if they're making a lack of consistency argument, but the bottom line is they're saying this is way off base. This is not an interpretation of the statute that deserves any deference under Skidmore. Look, now what I found so interesting about this was not so much that the taxpayer took a shot at this. I clearly understand that. What I thought was interesting and what caused me to put this on a slide was the IRS responsive filing in the circuit court. Look at what I say how the IRS responded toward the bottom of the slide. They say the reg is nothing more than a codification of the economic substance doctrine and Gregory versus Helvering. So in effect, what they're saying is the reg adds nothing new, so don't invalidate it. Wow, I thought that's amazing, right? Look at the position they've put themselves in. They've painted themselves into I'm not sure they painted themselves into a horrible corner. I guess it's the Supreme Court that may have painted them into a horrible corner. But look at what they're saying. How can this work? If they want to defend regulations, are they going to be saying, we didn't say anything of significance, so therefore don't worry about it? Well, if you didn't say anything of significance, then we should win the case, the taxpayer will say, right? Yep. So I mean, then, you know, if you've only got the economic substance doctrine and you only have Gregory versus Helvering, make those arguments, but don't bother us with this regulation should be the taxpayer's response. So it shows you how, I think it shows you the point that I'm making. It demonstrates the point that I'm making, that the IRS has a weakened hand. And here you see it in operation. This is the best they could muster. Now, maybe over time, they'll think of something else, something I haven't thought of, they haven't thought of, but I think Loper is powerful. This is a real anti-regulation kind of sentiment behind Loper, driven, I think, by, as I said before, regulation in general. And you know, we appreciate the court's a conservative court. The three liberal justices did not want to overrule Chevron. And here you see it playing out very, very, very starkly. And I think this is a great moment, which is, you know, in terms of how the response that they could muster, not a very vigorous one. Okay, at the bottom of the slide, I say, what about these new proposed regulations on basis shifting? You know, there's these new regs on basis shifting in the partnership area. There's revenue ruling, I think it's, if I remember correctly, I think it's 2024-14, and there's some proposed regs. And the IRS was trying to go after what it considered to be abusive transactions. And I believe I saw a letter in tax notes from, I think, Robertson Holland, pointing out that, you know, under Loper, these regs may not be valid. So this is not just me telling you this. This is, I think, you know, the point here is Loper weakens the IRS in terms of defending the validity of regulations. How weak? Time will tell. Next slide. Okay, I probably can jump over this. Do we have a few more minutes, guys?
Finish up.
Okay.
Go through
So
it.
this is just a point I've made in my tax notes article, which I think is interesting. I don't know if it's got practical bite, if you will, but you know, the conservative justices have pretty much embraced, not pretty much, they've embraced this idea of textualism. This is an orientation that informs how they interpret statutes. And they're very much committed to this concept of textualism. And what's interesting is, in my view, and I don't have the time to take you through all of the ins and outs of this, but in my view, the principal objective of textualism is to avoid or eliminate courts getting involved in policy questions, right? They want to resolve the statute, the meaning of the statute based on its text. And they don't want to look at what was the purpose of the statute. Why did they enact the statute? They don't like that. They say that's a job for Congress, okay? And that's not, we're not competent. We don't want to do that job. Our job is, what does the text say? If you don't like our conclusion about what the text says because you think the text is problematic, go back to Congress and get an amendment. But that's Congress's job. And interestingly, so while under textualism, they don't want to do any policy work, under Loper, they are taking back, in effect, policy work. Because under Loper, policy decisions, excuse me, let me start that sentence again. Under Chevron, a lot of policy work was being done by the agencies. When the agencies resolved what an ambiguous statute meant, they were in effect bringing to the table policy thinking. What are the consequences of our various interpretations? And they were making implicit policy judgments as they tried to resolve ambiguity in statutes. And now in Loper, the court is saying, we don't want the agencies to do that. We'll do it. We'll determine what the best meaning of the statute is. So there's an irony here, or a paradox, if you will. While these textualist justices don't want to do policy work, those very same justices in the majority in Loper are in effect taking back to themselves policy type questions. And I don't think, if you read Loper carefully, if you read Justice Roberts' opinion in Loper, I don't think he adequately answers this issue. I deal with this a little bit in the tax notes article. Next slide. Okay, so here I say, and I think this is worthwhile spending a moment on, do we have another slide or is this it?
Yes, you do.
One more?
Yep.
Okay, so this is, I think, worthwhile. Maybe we'll skip the next slide, but this one I think is important for us to spend a moment on. So what I say here is Loper is part of a larger anti-deference movement, okay? There's the conservative justices have been, and even some of the other justices as well, have been concerned about deference. And so there was this other kind of deference that we haven't talked about today, established by the court in this case called Auer versus Robbins, okay? And this was a very troubling concept. And I, you know, for tax people, I think it was terrible, very scary, okay? Under Auer, you could be litigating with the IRS about a regulation. Forget about validity. There was ambiguity in the regulation. So now we're not talking ambiguity, excuse me, I'm sorry. Now we're not talking validity, we're talking about ambiguity in the regulation. You'd show up in court and the government would file a brief and they would say, we confess that the regulation is ambiguous. But you got to remember, we drafted it and we knew what we meant, and here's what we meant. And the bottom line is taxpayer loses, okay? I think I called that in my big article on deference years ago, a pernicious form of deference. It was very troubling to me that the IRS could show up in court and say, we win, resolve the ambiguity that we left in the regulation our way. You know, I thought that was very troubling. And in the Kaiser case in 2019, the Supreme Court cut back an hour. And in my view, without working you through the ins and outs of it in the moment, footnote 6 was a really important footnote for the tax world. In my view, I think we discussed this actually in our book, Jonathan. In our view, it really cut back this concept of deference, this idea that the IRS could show up in court and say, oh, the regulation's ambiguous, we win, cut it back quite considerably, and probably as a practical matter, eliminated it for us as tax lawyers. That was my take. That is our take. So that's that. But here's the interesting thing. Here's and I'm just throwing this in almost gratuitously, but I was so taken aback by this that I had to throw this in. Here's a recent case that just came down, 2024 case, SN Worthington in the tax court, turns Auer upside down, very favorably to taxpayers. And so worthwhile having in your back pocket if you're talking to the IRS or in court about an ambiguous regulation. This court says that if there's an ambiguity in the reg, it should be construed against the IRS because after all, the IRS drafted it. You know, it's a similar concept, an analogous concept in contract law. If you remember in contract cases, if there's an ambiguity in the contract and one party drafted it, the ambiguity gets resolved against the drafter. And analogously here, the ambiguity gets resolved against the drafter of the regulation, against the agency. So a very important case that turns upside down what we used to think, what we used to be afraid of, which was our deference, is now pretty much gone, and we've now gotten the opposite of it. And so you see a kind of shift, and I think it's part of this anti-deference movement. There was a case this morning that I read in the DC Circuit that very much reminded me of this S.N. Worthington case. They didn't formulate it exactly in these terms, but in this DC Circuit case, I think the name of the case is, I don't know how to pronounce it, Rawat or something like that, R-A-W-A-T. It was decided yesterday. And in this case, the court said, gee, the regulation could be read to support the IRS's position. The regulation could also reasonably be read to support the taxpayer's position. And then the court went ahead and ruled for the taxpayer. It didn't own what it was doing, which I think what it was doing was it was resolving, as the Worthington court did, the ambiguity against the IRS. Didn't explicitly say that, but it said it could be read either way, and then it, in fact, ruled for the taxpayer. So it's worth taking a look at as well as Worthington, because that's the DC Circuit, which is a little bit more important than just the tax court. Okay, next slide. All right, so I don't know how important this will be to people who are at the front lines of practice in the moment, but here's something that I think is interesting, and I'll wrap it up here. So under Chevron, this is the last piece of change of how things are going to be different under this new world. Under Chevron, when a new administration came in, it could go back and look at regulations that were generated by the predecessor administration and say, hey, we want to amend those regulations. And there were some limitations on that, but that was not a problem. Chevron talked about the need for agencies to have flexibility and change over time, changing circumstances, being able to adapt. And so under Chevron, as a general matter, that was permitted. And the lack of consistency, hey, the prior administration interpreted the statute differently, or it's not contemporaneous. The statute was enacted years ago, and now we want to change positions. Those were not issues. Well, now, although the court in Loper doesn't explicitly address this, given these two big C's, it seems to me that the ability of a new administration to revise the output, the regulatory output of its predecessor, is going to be much more constrained, because anybody who's going to be adversely affected by this is going to come in and make the two big C argument. So I think we may see less of this. This may be a change. The court doesn't really anticipate or discuss it in any overt way, but I think this may be, it could be on the way. Final point I make is, what about, I've heard somebody, I've thought of this, what if a new administration withdraws a pro-government reg and adopts instead a pro-taxpayer reg? Could there be a challenge? And, you know, could you say, well, you know, maybe this new reg is not valid because it's not contemporaneous, it's not consistent, it's just a new administration. Will the reg be challenged? And I like the reg. This new reg is really good. I mean, think about it. Say President Trump gets elected and reelected, and he issues some new regulations that are really helpful to taxpayers, revising, maybe he takes the regs under the Secure Act, the 10-year rule, which we find problematic. Maybe he writes a reg saying, oh, taxpayers can have it the way they wanted it. Will we have to worry about that? I don't think so as a practical matter, because if the new reg gives you the benefit, pro-taxpayer, who's going to have standing to challenge it, right? Who could come in and say, oh, that's an invalid reg? No taxpayer is going to do it. Taxpayer is going to love the new beneficial approach. So I think as a practical matter, the government could probably still come in and issue new regulations, even though they're not contemporaneous, even though they're not consistent, and probably give it away to the taxpayer, because there's not going to be anyone available to challenge. As you know, you can't challenge something in court if you lack standing. So I think that's probably how that would shake out. Okay, so I'm ready to pass the baton to the next generation. So Anybody have
Jonathan,
any
do you have
comments
just a
or
couple?
questions? I'm happy to try to take a shot.
Jonathan, do you want to pose any questions to Mitchell, or do you have a couple minutes? We'll just talk about some of the other points on what practitioners should be doing.
I think, Marty, we've got to turn to what practitioners should do now in light of Loper.
Okay. Bob, did you make it on?
Yes, his pretty face is there.
I don't hear him though.
I'm here, Marty.
So Bob, one of the questions that comes up, and we don't have a lot of time, but I think it's really important. What do practitioners think about in light of all that Mitchell just said in terms of filing a protective claim for a refund or amending a return? How do we guide practitioners?
Well, let's start with, I want to say that I don't think the standard of care is well defined at all. And I think it's a very dangerous thing to say that the CPA firms Mitch drives by on his way home tonight somehow are responsible for understanding all these regs and what's right and what's wrong. Now, but if it is a major issue in a return, the CPAs have to be able to flag those issues or try to flag those issues and get with someone that can advise them how to file those returns, how to file the 8275 Rs, which are a mandatory disclosure when you go against the regulation, and determine how to best set this up. Because I want to come back to something that you guys said earlier. I think these arguments begin with the tax return, not on audit, not on appeals, not in the court system. And it's very important to get tax lawyers involved early so that those arguments are set up right. So, and going through, there's a list you have in here, Marty. Mitch talked about that wrongful death case under 2053, Mitch. I have that. I just signed a return where we were required to file the protective claim form with the return, even though when my guy was involved in a fatal accident, another person unfortunately was killed. That person is suing, the person's estate is suing him. In 2000, I would have had two 70-year-old litigators give me an opinion on what that case was worth, and that's what we would have put on the 706 as far as the 2053 deduction. Today, right now, or at least before Loper, I was stuck with the protective claim form, and now there's a great question. You know, what do we do there? But I think this goes, there's probably a dozen areas, and maybe the challenge for Mitch, you and your professor colleagues, is to give us a list of 25, 50, 100 things that where the regs may be open to challenge, so we can identify those, flag those, and bring in somebody to help us.
Well, you know, Bob, it seems as though any anti-taxpayer regulation is subject to challenge unless it's already been vetted by the Supreme Court. I think if you have a lower court decision which said, yeah, the reg says this and it's a valid reg, that won't block a taxpayer from saying, no, I'm not bound by that. The Supreme Court said if it's already been decided that the reg is valid, but who decided that? It would have to, I think, Mitchell, do you agree, would have to be the Supreme Court to foreclose a taxpayer from arguing that the regulation in question is not to be enforced. That's a very important thing because, you know, so much of our practice is based upon regulations. And now you can take the position that the reg just isn't valid. And I just think that this puts a big burden on everyone to consider filing claims for refund where you've got a regulation which may seem clear on its face, but it's an interpretation which may not be entitled to deference under Skidmore, which is what we're dealing with now. We no longer have Chevron deference where if the reg said something, you are pretty much bound by it, almost all cases. Now under Skidmore, you can take a shot in saying no, for whatever reason, whether it's lack of contemporaneous issuance or because it's inconsistent or just because it's a new interpretation.
I would say as a rule of thumb, just off the top of my head, because I haven't given this a lot of consideration, but I would say that in any case where the rule is not in the statute, is not in the code, but there is a rule in the regulation that I would say practitioners should take a hard look at that.
And you
I
can
think
imagine
a
that,
hard look is appropriate whenever you're dealing with a situation where there's no indication of that rule in the statute. Now,
and
by the way, you know, the court in Loper did say that if a court, as a matter of stare decisis, if a court had previously held that the regulation was valid, it's not subject to re-examination. So that's just a matter of stare decisis. But if you're dealing with a case where a court has never upheld that regulation, like for example, the 2009 reg that you and I are discussing, Bob, and that you have in your practice right now, right? That's never been upheld by a court, as far as I know. Yeah, I mean, and there's nothing in the statute which suggests what they did is appropriate there. I think a hard look is clearly required.
well, Mitchell,
By the
suppose,
way, the hard look is not that complicated, right? I think you come back to the two big C's, right? And maybe the third factor that I threw in on that slide was the two big C's. Have they been consistent? The agency been consistent? Were they contemporaneous? No in both of those in the 2009 regs. And then the third one, which is particularly interesting there, was it was in the heat of litigation. They were trying to overturn precedent. I think that's going to be not very well accepted or permitted under Skidmore.
well, a couple of points. I think that it's relatively rare for a court to rule that a regulation is valid. I mean, taxpayers really challenge a regulation. But even if you had one where the court said, yes, it's a valid regulation, if that's not the Supreme Court, is a taxpayer really going to be bound by it? Suppose you have a district court which says, yeah, they've challenged this regulation, I find it valid. I don't think that would stop, you know, another
Let's
tax.
take that hypo. That's a good hypo, Jonathan. So let's flesh it out a little bit. Let's assume that we here are in New York, right? We're practicing in New York, and there's some authority in the tax court upholding a regulation, okay? And let's say there was an appeal to the Second Circuit, and the Second Circuit upheld the regulation under Chevron, okay? According to Loper, that's entitled to stare decisis effect, okay? But I don't think that stops it. Now, that's what the majority said, and they didn't explore this in any more granularly than that. But in my thinking about it, it seems to me, what stops the taxpayer from now coming in and saying to the Second Circuit, right, or the tax court, we know that it's stare decisis, but we think if we can get this case up to the Supreme Court will now analyze it under Loper, Skidmore, and maybe invalidate it. I don't know. I mean, I don't think that a lower court decision, tax court, district court, or circuit court should necessarily preclude a Loper/Skidmore challenge at this point. We don't know the answers to these questions. The court just threw out there, oh, don't worry, if a court had upheld the reg under Chevron, we're not going to go back and re-examine that as a matter of stare decisis. But as you say, Jonathan, you know, what stops a higher court from chiming in?
And one of the things that it's right here on this slide that I worry about is a practitioner, including an accountant, going to be liable for failing to tell the client that, you know, you could challenge this. It's a bad result for you. And are you going to be liable for a failure to tell the client to file at least a protective claim for refund?
You know, it seems counterintuitive to me. I think I was quoted about this in the Journal of Accountancy recently before Loper was decided. They interviewed me about what I thought for accountants. And it seems, I don't know the answer, but it seems counterintuitive to me that an accountant should be required to be sensitive to Loper and Skidmore versus Chevron and how the validity of regulations is now tested differently. It feels like it's more of a legal issue than it is an issue of accounting. I don't know. I wonder if in the retainer agreement there could be a carve out that, you know, we don't, you know, questions of legality such as validity of regulations is for lawyers and not for us. I don't know. I don't know if it would work or if that would be sufficient.
Bob?
Well, I think it's, I'm somewhat supportive of Mitch's point, but the statute that enables CPAs to practice in front of the service, the next paragraph in that statute allows lawyers to practice in front of any agency, and they're worded exactly the same. So that's a little scary thing. But there has to be collaboration. And I think it really comes down to, I don't think, I'm more supportive of Mitch's point. It is unreasonable. So everything I learned about the Constitution was outside of my accounting program, so it's unreasonable to think that a CPA would be able to spot those issues, understand the difference between Chevron, Loper, all the wonderful things Mitch took us through. But they probably should, it's beyond the standard of care, but it'd be wonderful if the CPA said, wow, if this reg didn't apply, it would save you $2 million. And then, is this reg valid? And then that's what you go to a tax attorney for. And you have that tax attorney go through the outline Mitch put together and try to apply that body of law. In the meantime, you have to do some type of, let's say it's only a $100,000 issue, you could not possibly litigate it. Then you do protective claims and you stand on the sideline, not a protective claim like a Form CP, Mitch, but a 843 protective claim type form. And you just sit on the sidelines until some 100 millionaire or billionaire litigates the issue. But you can do that, Jonathan. You can file a protective claim, keep that statute open, and just wait.
And Bob, what if the CPA doesn't advise the client to do that? But it turns out later that the regulation, which was hurting the client, even though, as you say, Bob, it was only a $100,000 issue, turns out to be invalid.
I think that is beyond the standard of care. I don't think it's reasonable to expect a CPA to be able to catch all that, Jonathan.
Well, I wonder whether lawyers will as well. Marty, what do you think?
I think that, look what we've discussed and what Mitchell has gone through. You have to first determine whether or not the statute itself directs the service Treasury to issue regulations. And you, Jonathan, and I think Mitchell also made it clear that the variants of the types of language used are significant. So sitting here today, we don't know what language, what magical incantation of, cantation of language, what terminology needs to be used to support the regulations that are issued so that they have a higher deference given to them. And then after that analysis, you have to go through the consistency and the contemporaneous. I think the cost to do the analysis, the uncertainties where we sit now today are so massive that I wonder how it's going to be practical for any practitioner to really evaluate this. I think as time goes on, we may find, for example, the insurance industry backs a claim by somebody to overturn the split dollar regs, and we may see more of those types of things. So I think we all have to be attuned to what we see in the professional literature and in the cases coming out where regs are challenged. But I think the task is daunting, and clients are almost universally sensitive to not only fees but incremental complexity. This is not a simple discussion to have. And I think that even as a tax attorney, I may want to say we need to bring in a litigator to evaluate this. How many clients are going to want to do that? I do agree very strongly with Mitchell's comment that every practitioner is going to want to put in their engagement letter or retainer agreement some discussion of this. I think when clients are doing planning or filing returns, we're going to want to mention the possibility of this. But how far are clients going to be willing to pay to even have this evaluated? I don't know.
Let's go to our next.
Probably wrap up. Maybe we could have each of you give some final concluding comments.
Well, Marty, let me mention the anti clawback regs. This is the one that they've come out with, and they've said, if you make a transfer, basically not really using the enhanced exemption before 2026, and you make a gift or you die after 2025, we may say you did not effectively use it. And there is something in the enacting legislation which might support the IRS doing something like that. But that's one area where I think, Mitchell, I haven't discussed this with you, but do you think that's an area, Mitchell, where a taxpayer might stand a chance to get those anti-clawback regs knocked down?
You know, Jonathan, we'd have to go back and look. My recollection is in 2001G, which is where the statute addresses this issue, that they give some authority to the IRS to issue regulations.
They do.
So I think that would probably come within that Loper passage, which would make it a very hard case to challenge. Is my, quick off the top of my head reaction to it.
But you can imagine having now trying to advise a client who wants to do something. You say, well, this probably would be caught by the anti-clawback regs, but go ahead and try it anyway, because maybe you can get the reg knocked down. Very, very tough for practitioners, if you ask me. That's basically all I have to say, Marty. Bob, what about you? What do you think?
Bob, before you comment, let me ask you a question. How would you advise a client that if they're going to take a position contrary to a regulation on a return and, file the form saying, hey, IRS, we've taken a position contrary to regulation, wouldn't you advise that client that that's going to increase in a meaningful way, potentially, the risk of an audit? And how many clients react to that?
You wouldn't file that form until you had litigation counsel lined up and you were ready to go and the client knew what it was going to cost to litigate that through the tax court, through, in my case, the Seventh Circuit, or even to the Supreme Court. And so when you say, the issue is a $100,000 issue and it's going to cost $1 million to litigate, people are going to walk away.
Yes.
Or they'll instruct you to file a protective claim and just sit on the sideline hoping that someone else enters the Coliseum and litigates it for you. I mean, that's what
I think that many clients would shy away given the cost and hassle and the audit risk of filing a position contrary to a regulation. Unless there's a lot of money at stake, it's just not practical.
There is a broader practical problem, is that I'm not so sure that there literally are enough tax attorneys to take on all these issues and to shadow all these returns that are being prepared. And so it becomes incumbent upon the ABA, AgTech, AICPA, professor groups Mitch might be in, even informal groups, to start to develop a list of the regulations that need the most scrutiny, where CPAs would automatically, if I have the wrongful death case, Mitch, from what I learned from you today, if I have a wrongful death case, I would have the client possibly engage you or someone you would recommend to start to lay this out for us and develop a strategy. And, there's this admission against interest idea. That means that our litigation starts when we file that tax return. That tax return can't have any possible admission against interest. When I've had things like this in the past, we have litigators, I've had John Porter do this a number of times, look at the returns that are going in, Marty, because I don't want to give him a mess to clean up.
Right. Mitch, any final comments?
Yeah, I would just say, welcome to the world of Loper and reduced regulation.
Well, Mitchell, you did a magnificent job. Really, thank you so much. As I've said, I've been following Mitchell on, Chevron, now Loper, for literally decades. It's an exceptionally important thing. I don't think it can be overemphasized how important the Loper case is. There are others who may disagree with that, but I think this is just a watershed change in practice for us.
Wonderful job, Mitchell. Thank you.
Yeah, thank you, Mitchell, and thank you, Jonathan and Bob. And everyone listening, keep in mind this is for educational purposes only. Do not take any action based on our comments today. And I wish all of us good luck. I think we have a lot of complexity and a lot of analysis that's coming before, down the road to deal with all this. So good luck, everyone, and thank you again to all the speakers.
Thank you, everyone.
Take care.